Hello, this is Monica Rahar, and today we'll be taking up the case of Roshan Khan and two others versus the state of UP and four others for our discussion. It's an Allahabad High Court decision which is dated 29th of August 2020. It was decided by a two-judge bench which consisted of Honorable Justice Shashi Gupta and Justice Shamim Ahmed. Now let's proceed with the issue of law. So the issue of law was whether a complete ban on carrying out the Moharram procession on 30th of August 2020 was a violation of the fundamental right to practice and profess religion, which is enshrined in Constitution of India. Now let's proceed with the brief facts of the matter. So a batch of petitions were preferred before the Allahabad High Court, which had the same issue of law and same set of facts. Therefore, the court decided to take these batch of petitions together. Under challenge in these petitions were the government orders dated 10th and 23rd of August this year, and these petitions they challenged these orders to the extent they prohibited petitioners and their community from carrying out the Moharram procession. So these petitions they sought direction for allowing religious mourning rituals and practices connected with Moharram during the period of 10 days, that is up to 30th of August 2020, while the COVID-19 related restrictions were imposed or they were in place in the state of UP. Now let's proceed with the contention of the parties and understand the case of the petitioners and that of the respondent clearly. So the first set of argument which was advanced by the counsel for the petitioner were that it was that these orders were discriminatory because they imposed a complete ban on carrying out the Moharram procession. And the second being that only one community was targeted. Now, here at this juncture, we need to understand one thing. These petitioners, before coming before the Allahabad High Court, they had knocked the doors of the Supreme Court of India and they sought the same relief which is sought in these petitions. The Supreme Court, however, did not grant such relief and also gave the petitioners the liberty to approach the Allahabad High Court. And therefore, the petitioners have come before the Allahabad High Court. So, by the second contention stating that only one community is targeted, the petitioners implied that when they approached the Supreme Court declined to grant them the relief which they sought, but the Supreme Court also, by way of three orders, allowed the following, which I'll be stating now. A is devotees' access to place of worship. So the petitioners contended that the Supreme Court allowed devotees access to places of worship. The Supreme Court also permitted the annual Jagannath Rath Yatra in Puri, Orissa, and also permitted offering religious prayers in three Jain temples in Mumbai. Now, the third contention of the petitioner was that these prohibitions were arbitrary because had the Moharram procession been allowed, the devotees would have observed certain precautionary measures which would have made sure that COVID-19 was not transmitted while the processions were carried out. Now let's proceed with the case of the respondent. So the respondent contended that the central government notification dated 29th of July 2020 authorized state governments and the UTs to prohibit certain activities or impose restrictions if they deemed such restrictions and prohibitions necessary in order to contain the spread of COVID-19. So, pursuant to this notification of the central government, the UP government also issued notification dated 10th of August 2020, seeing the rise in COVID-19 cases in the state, and by virtue of these notifications, all processions in August of all communities, be it Ganesh Chaturthi or Janmashtami or Moharram, all of these were banned. And thirdly, the state respondent contended that restrictions were reasonable and not violative of fundamental rights because they had the processions been allowed, they would have caused chaos and rise in COVID-19 cases. And fourthly, this respondents contended that in any also in an earlier petition, the Supreme Court refused to grant such a relief and gave liberty to the petitioners to approach the Allahabad High Court. Therefore, the High Court should also follow the lead of the Supreme Court and decline to or refuse to grant such a relief. Now let's proceed with the reasoning and decision of the High Court of Allahabad. So the High Court of Allahabad stated that the petitioner's plea of discrimination has no legs to stand because these restrictions were imposed on all communities. Ganesh Chaturthi, Janmashtami, these were equally banned too to avoid congregation of people, which would have led to rise in COVID-19 cases. The court rightly stated that these restrictions were needed since UP was and still is in community transmission stage, and therefore, and also it is on the fourth spot in the country in the number of COVID cases. Therefore, keeping in mind that a discrimination was not there because these prohibitions were imposed on equally on other religious communities as well, and also that it was the need of the hour. Therefore, the plea of discrimination has no legs to stand. Now, with respect to Supreme Court allowing other religious congregations or processions and not allowing the Moharram procession, the Allahabad High Court observed or stated that Supreme Court granted permission for limited areas while also considering the COVID-19 status of the place where these permissions were given. For instance, in Puri, the Jagannath Rath Yatra was permitted for a specific area from one determined place to another, keeping in mind the status of COVID-19 cases in Orissa. The court further observed that, contrary to cases before the Supreme Court, in wherein permission was sought for a particular area, in the cases before the Allahabad High Court, permission was sought to allow the taziyas for entire state of UP. So the court therefore held that no restrictions can be placed on only certain groups or individuals while permitting the others, as it would amount to forming a class within a class, which would be arbitrary and discriminatory. Now, what did the court mean by this was that since the permission in these petitions was sought for the entire state of UP, therefore the court was not it was not open to the court to allow certain areas or districts or places in the state of UP to carry the Moharram procession and not allow the others, because that would have amounted to creating a class within class. So therefore, differentiating the cases or the nature of cases before the Supreme Court from that of the nature of the petitions here, the court marked the distinction that before the Supreme Court, the cases sought permission for a limited area, while in the cases before the High Court of Allahabad, the permission was sought for the entire state of UP. Now let's proceed with the next reasoning or what was held by the observation of the court. So the court noted that Tazia's burial being a solemn or important part of Muharram, every locality has Tazias, all of whom has to get to the burial ground personally. And no mechanism is in place to check COVID-19 transmission. And even the petitioner's counsel could not suggest any such mechanism when asked for. Also, therefore, the court held that the complete prohibition on essential religious practice is extraordinary, but it is proportionate to the unprecedented situation which is posed due to COVID-19. The right to practice and propagate religion has been made subject to public order, morality, and health, even in our constitution. Therefore, the petitioner's prayers were not granted. Now, I'd like to read the paragraph in which the court stated that we need to proceed further as one nation and support each other, and also take into consideration the unprecedented situation that we're facing right now. So the court held that with a very heavy heart, we hold that in these testing times, it is not possible to lift the prohibition by providing any guidelines for regulating the morning rituals and practice connected with the 10th day of Muharram. We must hope and trust that God would perceive our restrictions in our customary practices not as a slight, but as an act of compassion for our brothers and sisters, and give us the opportunity to celebrate all festivals with greater faith and fervor in future. It is only together with cooperation, understanding, and support we as a we as one nation can emerge stronger from these treacherous times and overcome this season of darkness. So that's all we have for this case. So essentially, what we needed to understand was that whenever right to practice and profess religion is contended, and if it contradicts with the matter of public health, then it can be restrictions can be imposed on practice on such a practice or such enjoyment of fundamental right, because that is provided for in our constitution itself. So at the end of this case note, we have a list of abbreviations which we've used in the note. You may refer to it for a clearer understanding. That's all we have for this note. If you have any questions, kindly feel free to write to us. We'll be glad to address your queries. And thank you for being with us.